Everyone, welcome back to Mayanklaholic. It's a humble request. Please subscribe to us. And here we are continuing the MCQ series of the Indian Contract Act. Let us start from the question number 101. Communication of acceptance is complete as against the acceptor only when it is put in the course of transmission, when it comes to the knowledge of the proposer, when it is communicated to the acceptor that the acceptance has reached the proposer, and option D, all of the above. Correct answer here is option B, that is when it comes to the knowledge of the proposer. Question number 102. X duly posts a letter of acceptance to Y, but the letter in post in transits by the negligence of the post office. Option A, there is no contract concluded because the acceptance has not reached the proposer, and option B, there is no contract concluded because the proposer has not received the letter. Option C, the contract is concluded because the acceptance is complete from the date of the dispatch, notwithstanding any delay or miscarriage in its arrival from the cause not within the acceptor's control, and option D, none of the above. Here correct answer is option C, the contract is concluded. Now let us proceed to question number 103. When the acceptance is made by telephone, when the contract is deemed to be made at such place. Option A, where acceptance is heard or received. Option B, where the acceptance is given. Option C, where the acceptor resides, and option D, none of the above. Correct answer here is option A, where the acceptance is heard or received. Question number 104. Consider the following statements. The communication of an acceptance is complete. Option A, as against the acceptor when it comes to the knowledge of the proposer. Option second, as against the proposer when it is put in a course of transmission to him so as to be out of the power of the acceptor. And which of the statement of the given above is are correct? Option A, one only. Option B, second only. C, both 1 and 2. And D, neither 1 nor 2. Here in question number 104, correct answer is option C, both 1 and 2. Both the statements are correct. That is, as against the acceptor when it comes to the knowledge of the proposer, the communication of acceptance is complete. As against the proposer when it is put in the course of transmission to him so as to be out of the power of the acceptor. Question number 105. In which case it was held that a contract through telephone is concluded at a place where the acceptance is heard? Here correct answer is option C, that is Bhagwan Das Govardhan Lal Kedia Measures and Sons versus Girdhari Lal Purushottam Das and Company, AIR 1966. Question number 106. A contract by post is concluded at a place. Option A, from where the offer has been made. Option B, from where the acceptance has been posted. Option C, where the acceptance had been received. And option D, where the goods are to be delivered. In question number 106, correct answer is option B, that is from where the acceptance had been posted. Question number 107. Consider the following statement. In Bhagwan Das Govardhan Lal Kedia versus Girdhari Lal Purushottam Das and Company, it was laid down that first, section 4 does not imply that the contract is made qua the proposer at one place and qua the acceptor at another place. Second, the communication of acceptance should be from a person who has the authority to accept. Information received from an unauthorized person is ineffective. Which of the statement given above is are correct? 1 only, 2 only, both 1 and 2, neither 1 nor 2. In question number 107, correct answer is option A, that is 1 only. Question number 108. The communication of an offer or proposal is complete. Option A, when it comes to the knowledge of the person to whom it is made. Here option A is the right answer. Question number 109. A contract over telephone becomes complete at the place where the acceptance is heard. In which case it has been held. Correct answer here is option A only, that is Bhagwan Das versus Girdhari Lal. Question number 110. In case of conflict of jurisdiction of courts, the incident of a contract shall be governed by the law of the place where the contract is made, contract is performed, acceptor resides, proposer resides. Correct answer here is option A, that is the contract is made. Question number 111. A proposal cannot be revoked. Option A, by failure of the acceptor to fulfill a condition precedent to acceptance. B, by the lapse of the time prescribed in the proposal for its acceptance. C, by insanity of the proposer if the fact of the insanity comes to the knowledge of the acceptor before acceptance. D, after the communication of its acceptance is complete. In question number 111, correct answer is option D, that is after the communication of its acceptance is complete, a proposal cannot be revoked. Question number 112. Revocation of offer by letter or telegram can be complete when it is dispatched, when it is received by the offeree, when it reaches to the offeree, both A and C. In question number 112, correct answer is option B, that is when it is received by the offeree. Question number 113. Revocation of acceptance under the Contract Act is provided under section 4, section 5, section 6 and section 7. Correct answer here is option B, that is section 5. Revocation of acceptance under the Contract Act is provided under section 5. Question number 114. Which of the following is correct under the Indian Contract Act 1872? Option A. An acceptance may be revoked at any time before the communication of acceptance is complete as against the acceptor but not afterwards. Option B, all agreements are contract, but all contracts are not agreements. Option C, a person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of sound mind. And option D, the communication of a revocation is complete as against the person to whom it is made when it is put into a course of a transmission to the person to whom it is made, so as to be out of the power of the person who makes it. Here in this question it has been asked which of the following is correct under the Indian Contract Act. In question number 114, the correct answer is option A, that is, an acceptance may be revoked at any time before the communication of acceptance is complete as against the acceptor but not afterwards. Question number 115. Which of the following statement is true? Option A, an offer can be revoked but an acceptance cannot. An acceptance can be revoked but an offer cannot. Offer and acceptance are revocable. D, offer and acceptance are irrevocable. Correct answer here is option C, offer and acceptance are revocable. This is the true statement. Question number 116. A proposes by letter sent by post to sell his house to B. The proposal of A is accepted by B by the letter sent by the post. When can A revoke his proposal? Option A may revoke his proposal after B sent letter by the acceptance by post. B, A can revoke proposal at any time before B sent a letter of acceptance. C, both A and B are correct, and D, none of the above. Here in question number 116, correct answer is option B. A can revoke proposal at any time before B sent letter of acceptance. Question number 117. A proposal is revoked, option A, only by the death or insanity of the proposer itself. Option B, by the death or insanity of the fact of the death or insanity comes to the knowledge of the acceptor. C, by the death or insanity of the proposer if the fact of his death or insanity comes to the knowledge of the acceptor before acceptance. And D, none of the above is correct. In question number 117, correct answer is option C, by the death or insanity of the proposer if the fact of his death or insanity comes to the knowledge of the acceptors before the acceptance. Question number 119. Which statement is not true? Option A, proposal is revoked by the communication of notice of revocation of the proposer to the other party. B, a proposal is revoked by the lapse of time prescribed in such proposal for its acceptance. C, a proposal is revoked by the lapse of reasonable time if no time is prescribed. And D, a proposal is revoked by not meeting at the time prescribed. In question number 118, correct answer is option D. D option is not true, whereas A, B, C are true. Question number 119. Which from the following statement is not correct? Option A, acceptance must be in writing, acceptance must be communicated, acceptance must be prescribed manner, oral acceptance is a valid acceptance. Here in this question it has been asked which of the following is not correct. Option A is not correct, that is acceptance must be in writing. It is need not necessarily must be in writing. Question number 120. To convert a proposal into a promise, the acceptance must be qualified, unqualified, general, absolute and unqualified. In question number 120, correct answer is option D, that is, to convert a proposal into a promise, acceptance must be absolute and unqualified. Question number 121. Which of the following is the valid acceptance of a proposal? Option A, when the acceptance is made in ignorance of the proposal. B, when the acceptance is made in usual and reasonable manner but not in a manner prescribed by the proposer. C, when an acceptance is made in a manner prescribed by the proposer. And D, none of the above. Here in question number 121, correct answer is option C, when the acceptance is made in a manner prescribed by the proposer. Question number 122. Where no application is made and no time is specified for the performance of promise, there the agreement is performed within 3 years, 2 years, 1 year reasonable time. In question number 122, correct answer is option D, that is reasonable time. Question number 123. To convert a proposal into a promise, the acceptance must be absolute and qualified, absolute and unqualified, unusual and reasonable, usual and qualified. Here in question number 123, correct answer is option B, that is absolute and unqualified. Question number 124. Which one of the following statement is not correct? Option A, oral acceptance is a valid acceptance, acceptance must be in writing, acceptance must be communicated, acceptance must be in the prescribed manner. Here in question number 124, correct answer is option B, that is acceptance must be in writing. This is not correct. Question number 125. Drawing cash from ATM, sale by a fall of hammer at an auction sale, etc. are the examples of express contract, implied contract, tacit contract, and unlawful contract. Here correct answer is option B, that is implied contract.